This case begins with claims of race discrimination, the kind of allegations that often sets the stage for everything that follows. And as so often happens, once the employee spoke up, retaliation became part of the story. Most retaliation cases end the same way. The employee is pushed out, but not this one. This time, the employee fought back, forced her employer to be held accountable, and even stayed in the very workplace where it all began. What happened after that wasn't just unusual, it was explosive. By the end of this case, you'll see how the courts draw the line between ordinary workplace conflict and unlawful retaliation, and why a signed settlement means you can't circle back to refight old complaints, even if you believe they are contributing to the discrimination and retaliation you're experiencing today. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider. And on this channel, I do more than share legal opinions. I break down real cases to show how the law might apply to your workplace, whether you're an employee trying to protect your rights or an employer trying to do things the right way. If you've watched retaliation videos on this channel, you have seen the pattern. An employee speaks up, experiences retaliation, and eventually leaves the company, because the experience of retaliation often pushes people out of their jobs. But today's case is different. In this one, a woman didn't walk away. She found the courage to confront her employer, hold them accountable for retaliating against her, and then she stayed. What happened next is what makes this case so remarkable and so troubling. All right, let's talk about it. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. Always consult with a qualified attorney or HR professional for specific guidance tailored to your needs. And hey, don't forget to like and subscribe. This story begins with Deidre Parker, who started her career as a federal employee in the 1980s. She joined the United States Department of Agriculture, or USDA, on March 6, 2011, as a GS7 Program Management Assistant. By the time she began working as a Program Management Assistant, she had already completed 25 years of service with the USDA. As the Program Management Assistant, Parker was the only Black program assistant in her department, or unit, as they were called by the USDA. Now, if you are not familiar with the USDA, it's the United States Department of Agriculture, and it oversees farming, food programs, and rural development. Inside the USDA is the Risk Management Agency, which handles crop insurance and financial risk for farmers. That's where Parker worked, serving as a program management assistant in the actuarial and product design division. Parker's role was meant to include not just clerical support like timekeeping, travel, and files, but also higher level duties like program planning and budget tracking. Yet in practice, most of what she did was administrative. On paper, her career looked steady. She was never demoted, her pay never dropped, and she was never suspended. Her performance record on paper was solid. But despite that, Parker believed she was being treated unfairly. In September 2013, she filed her first EEO complaint, accusing the USDA of discrimination and retaliation. That case was settled in May 2015, and as a part of the settlement, everything that happened before May 29, 2015 was off the table. In other words, Parker agreed she couldn't go back and fight or even revisit those earlier claims. But from that point forward, Parker said things only got worse. In February 2017, Parker filed another complaint. This one became known as her 2016 complaint. In the complaint, Parker alleged she was being sidelined because of her race, her gender, and her prior complaint. She said that after the 2015 settlement, her workload dropped to almost nothing. She was desperate for meaningful assignments, so she started asking about temporary assignments, what the government calls details, in other areas of USDA. In January 2016, she asked for a temporary assignment in the Acquisition Management Division, which handles government contracts and purchase purchasing, but her own division refused to keep paying her salary during the move, so the request was denied. In federal agencies, when an employee takes a temporary assignment called a detail, their home unit has to keep paying their salary even while they're working somewhere else. In Parker's case, that meant her regular office, actuarial and product design division of the risk management agency had to agree. Without that agreement, the detail couldn't happen. So when she asked for a temporary assignment to the acquisition management division, her supervisor said they wouldn't keep paying her salary. As a result, the request was denied. Around the same time, she asked about working in classification, the HR office that decides job titles and pay grades. But she was told there weren't any positions that she could fill. In July 2016, she was offered a 60-day assignment in a USDA warehouse under the Farm Service Agency. That's the USDA branch that provides loans, insurance, and other support directly to farmers, but it was a GS6 role, which made it below her pay grade. So she turned it down. By August 2016, she asked about a liaison position, basically a go-between role that connects different parts of risk management. But by the time she asked about the job, it had already been filled. Eventually, in November 2017, she did get a 60-day assignment with the Farm Service Agency. And in March 2018, her supervisor, John Underwood, assigned her to work on a report tied to the Federal Employee Viewpoint Survey. Parker believed those assignments didn't come because management wanted to support her. She thought they only happened because she had already filed multiple complaints, going all the way back to her first one in 2013 that ended in a settlement. Parker also argued that several white women were promoted while she was passed over. She even listed their names in her complaint, but she didn't provide records, dates, or evidence showing who applied, who was selected, or why. For some, she admitted she didn't even apply to the position because she believed management had already picked their favorites. Then on May 6, 2016, Parker went to a little restaurant called the Beacon Cafe that was located inside her office building. She ordered an egg sandwich, undercooked, and requested a new one, but the staff refused to make it for her. A manager eventually remade the sandwich, but complaints started circulating that Parker was disruptive and spending too much time away from her desk. 2 weeks later, on May 20th, her supervisor, Ron Lundine, verbally counseled her, basically told her to stay out of arguments with the cafeteria staff and to limit her time there. And by July 11th, 2016, she was formally counseled in writing. Why? The cafe had accused her of a continuing pattern of disruptive behavior, and they banned her from the cafeteria for 90 days. Then on December 6, 2018, Parker filed her third and final complaint with the EEOC, even while her second complaint was still pending. In this third one, she said that after an August 8th mediation with her supervisor, Ron Lundine, he stopped speaking to her face-to-face and switched to email only, which she claimed was retaliation. Then coworkers started filing complaints against her. Julia McKeague, a statistician, said when Parker became frustrated with a colleague, she stated, "If this bitch doesn't leave me alone, I'm going to kick her ass." Parker later admitted to saying it, but she also said it was a joke. McKeague didn't find it funny and filed a formal report. Stephanie Cole, a newer employee, reported that Parker made comments about race, stood too close in Cole's personal space, and even asked her for cash, $5, which Parker repaid later. Cole also said that she felt Parker was physically intimidating. Then on August 24th, 2018, Parker's supervisor, Ron Lundine, counseled her again, telling her not to threaten coworkers, not to comment on race, and not to invade personal space. Parker denied most of the complaints, but admitted to the kick her ass comment. Then things escalated. On September 4th, 2018, the agency called in the Federal Protective Service, the federal law enforcement, to investigate Parker's conduct. Coworkers were interviewed. Parker said learning about the investigation pushed her over the edge. And on September 10th, 2018, she retired, but not quietly. Management said Parker left a voicemail implying that she might hurt someone if she stayed, and that voicemail was taken as a threat of violence, enough that when she came to sign her retirement paperwork, she was escorted out of the building. After finishing the process with the EEOC and getting a right to sue notice, which is basically the green light that lets an employee take their case to court, Parker filed a lawsuit against the USDA in December 2019 in the Western District of Missouri. In that lawsuit, Parker raised the same allegations of discrimination and retaliation from her 2016 and 2018 complaints. She also claimed constructive discharge, which means she argued her working conditions had become so intolerable that she was essentially forced to resign. In its defense, USDA argued that Parker's assignments and counseling were legitimate management decisions, not retaliation. They said the promotions she wanted weren't denied based on race or gender, and that the 2018 investigation and counseling were reasonable responses to workplace issues. And the district court, they ruled against Parker. The judge said everything before May 2015 was waived by her settlement, so she couldn't bring it up. The judge made it clear that everything that happened before May 29th, 2015, the date of the first settlement, was waived. That meant she couldn't rely on any of those earlier events in her lawsuit. Parker argued that the discrimination and the hostility at USDA had been ongoing for years, so even the older events should count as a part of a continuing hostile environment. But the judge rejected that argument. The May 2015 settlement, the court said, was final. Everything before that date was waived and off the table. The only claims the court would consider were those from 2016 and 2018. And those reduced duties, details, or temporary assignments that were denied, and cafeteria counseling did not amount to adverse employment actions under Title VII. The evidence just didn't show a hostile work environment. The behavior Parker experienced simply wasn't severe or pervasive enough. In February 2025, the appeals court affirmed judgment in USDA's favor. This case is another reminder that not all bad treatment at work rises to the level of legal retaliation, but it's also a lesson in knowing when it's time to move on before the situation changes who you are at your core. Parker was working out of the USDA's Beacon Complex in Kansas City, Missouri. I actually covered the history of race relations in Missouri in another video called DEI Gone Wrong. If you haven't seen it, that video will give you more context about the environment Parker was working in, not just inside the USDA, but in the community itself. Parker's